afternoon, everybody. Let's call this work session of the Assembly to order. We'll begin by taking a roll call. Mr. Tucker, will you please start us off?
Julia Tucker, Assembly Council.
Jennifer Johnston.
Ernie Hall.
Bill Evans.
Amy Domboski.
Dick Trainee.
Patrick Floyd.
Pete Peterson.
Mr. Wheeler, you want to say hello?
Dennis Wheeler, Mr. Attorney.
Thank you, Mr. Wheeler. We're here this afternoon to quickly go through, we'll probably spend most of our time on Ms. Johnston's version, that we have before us. We'll also, I'd like perhaps the union just give suggestions. And I'm going to turn this over to the chair of our subcommittee, Mr. Evans. I appreciate all your hard work. Dave, the floor is yours.
Thank you, Mr. Chair. What I was thinking I'd do is just give you a couple minutes of background on what the subcommittee has done thus far, put everything in context for you for today's discussion. As you know, we've met a handful of times over the past 2 months. The reason the subcommittee was created initially was concern about the potential expense of having the AO37 referendum on the ballot in November. There was concern that it would cost in excess of $400,000 to do so. So our mission, at least initially, was to see if that expense could be avoided. And I think a subtext to that was to see if a compromise could be reached between the administration and labor that would obviate the need for a referendum in the first place. We had several meetings. On the good side, we were able to work with the municipal clerk and the state clerk, and we have the referendum on the state's ballot in November, which eliminates the cost concern. Should be a very minor cost, if any, to do the election in November if it goes that way. We had 2 proposals that were advanced during our committee meetings. One by Mr. Trainee was a straight repeal of AO37 that would eliminate, obviously, the need for a referendum and would give the parties time afterward to address any labor issues in a deliberate manner. We also had a proposal by Ms. Johnston that was sort of a revision of Anchorage Municipal Code 3.70, which was the same code that was revised by AO37. Ms. Johnston's proposal has a number of factors. The bulk of the time the committee spent was on going over Ms. Johnston's proposal. We had participation in all our meetings from the various labor unions who were actively involved in the process. They met with us in groups and sometimes individually. I would say that both sides, Ms. Johnston, Mr. Wheeler, who put together that proposal, and the unions worked hard, I thought, during the process to try to find common ground, and certain progress, I think, was made towards that. I think both sides had a good faith, made a good faith effort to reach agreement. As you've seen, we had the latest, we received proposals, amendments from the union, from Mr. Aslan, on behalf of the group of the unions that I think Ms. Johnston will address. And so since it's mostly her proposal that I think we're looking at today, I will further turn over the discussion to Ms. Johnston, unless there are any questions about the subcommittee's actions.
Just a gentle reminder, the other reason we formed the subcommittee was there is concern that we have not yet validated that there are federal monies for public transit that could be placed at risk were some of the provisions of AO37 to become law. And so it's the other financial reasons looking into this.
And one thing I did want to mention is, as things currently stand, if the Assembly does nothing, then AO37 goes to referendum in November. There is a time crunch we're sort of facing of, I think is it August 18th?
August 18th.
18th is the date on which we have to notify the state if we were going to take it off the ballot. We may be able to do it after that time, but we're on the state's good graces.
Forbearance of the state after that date.
Forbearance of the state, that's exactly right. So that is why August 5th is sort of a critical meeting for us if we're going to do something about getting it off the ballot before August 18th.
Thank you for that clarification. Thank you.
Mr. Julia, if we do not take any action to repeal Let's say if the public at large repeals 37, how long is it before we can address anything that was in that law that was passed by the body? Is there a time
I
constraint?
think there's a 1 or 2 year moratorium. It's at least 1 year, and it may be 2 years. I'd have to double check and look it up, but once, if something, goes to the ballot on a repeal referendum, then, and it's repealed by referendum, then there's a time limit of at least a year, and it may be 2 years in code that it's not, the things that were encompassed within that cannot go forward.
Thank you, Judith. Thank you, Mr. Chairman.
Ms. Johnston?
One other correction, I think in our committee, it wasn't to meet an agreement between the administration. It was actually completely an assembly. I have no support from the administration in my effort, except that I've used the administration as a resource, but without their support. So I want to set that, clarify that. My intent, if it's all right with the chair, is to go through this matrix that we used during our committee meeting, and Mr. Wheeler and I will be doing the document show, I guess.
Thank you, Mr. Chairman. We only have an hour.
Yep.
And I think that it's really important, and you may already have a plan, Ms. Johnson, but I think it is really important that we go over the latest, 11:48 p.m. last night, proposed amendments from the
Okay,
coalition.
and be honest, yeah, and I will try to do this quickly if there's not many questions. I just want you to know how I got to where I'm at
Right.
with the ordinance that's before us on
Right.
Tuesday night. And to set the record, I've started out each meeting by saying that it is my intention to, if we could hit something down the middle, that we would need 8 votes from the assembly. And if we don't have 8 votes, and it looks pretty apparent by Tuesday night, there's not 8 votes, my intention will be to postpone this indefinitely. I also will postpone it indefinitely if there's a public filibuster. So don't worry about coming out and speaking against this. I will be postponing it indefinitely. I don't want to tie up the assembly's time with that kind of effort again. So as we go forward, I just want you to know this is where I stand on this ordinance. We'll go through this matrix. I'll try to do it quickly. And then whoever wants to comment on the union's response, that's fine. We'll start with number 1.
I wasn't finished, Mr. Chairman. You know, I don't want to take up a whole lot of time, but I just want to make sure that we get to these comments today. And also, Mr. Johnson, I just want to remind you in terms of filibusters and public hearings, we have some new rules concerning public hearings. Thank you, Mr. Chairman. I'm done.
This is the only work session we have today, so if we run a little bit over, it's probably okay.
Excellent, excellent.
Ms.
Anyways.
Johnson, please proceed.
On this matrix, with the question and answer matrix, we'll go to number 1. And we will, Mr. Wheeler.
Thank you. Through the chair, assembly members, number 1 is, I think, pretty straightforward. If you look at the response lines, there were 2 basic questions and 2 responses to those questions. The first one is to, if you will, normalize holidays across all of our employees. And point number 2 is to just simply clean up the definitions are not needed in light of pulling out the provisions regarding managed competition that were in a policy statement in AO 37.
And as you know, this is revisions to our current code. It's not to AO 37, so managed competition is not even a part of this. Number 2, equipment decisions. Again, Mr. Wheeler.
Right, so if you turn to page 6, which has to do with management rights, there was some back and forth discussion about how does this provision tie into what might be negotiated between any one union and the administration. We've added some language at the suggestion of IBEW. You see that at lines 26 and 27, so that it preserves the this notion that while management rights are reserved to the administration and the municipality, that if otherwise specifically approved by the assembly, there could be some deviation from those provisions. That coincides with a policy statement that's in subsection B in the next page that talks about there being nothing incompatible with the maintenance of those rights and the notion of trying to negotiate in good faith regarding subjects, and we touch on those. So that's something new. It's in the S version.
And just for my intent here is I've always said that these are rights that unions can, I mean, the management can give or address with union agreements. And I'm just saying, each time you set the clock back, and the management needs to know that this is their responsibility. We are self-insured. I don't care who the assembly is, who the mayor is, the management needs to know that they're responsible for the city and the risk. And so no matter what happens, I mean, I know that the unions are responsible for the safety of their employees. And the management is responsible for the safety of employees and the risk to the city. Those things lots of times interrelate very well. And it's not something that's taken off the table, it's just a reminder.
Ms. Kowalski?
Are we taking questions as we go, or do you want to hold them to the end?
What's easiest for you?
Either's fine with me, one as we go.
All right.
Yeah.
I'll try not to pontificate.
That's good.
No promises, but I'll try. Ms. Tucker, I briefly discussed with you my concern about some of these equipment and staffing scheduling issues. From our conversation, when I can only relate this to the fire department because it's the department I know the best. But I'm very concerned when I see this language being injected into the ordinance that from an Eagle River perspective, a city manager or a mayor can say, now we're just gonna run a two-man engine out there. So from what you see here, does this alleviate that concern, or do you think that's still a valid? I'm asking Ms. Tucker.
I don't think that it alleviates your concern, but I think it's good to hear from the sponsor on how they're interpreting it. But I think that that's the whole contention, as it was in the prior AO 37 and is here now, about where the things that Assemblymember Johnson said, and I think that Mr. Wheeler acknowledged at the last work session that I attended, that are in those gray areas where there's a rub between what management has the ultimate right to do and what needs to go to bargaining team.
And I guess I'm asking from a legal perspective. I heard Mr. Wheeler's assessment of it, but I'm wanting to see if there's a gray area to protect the public, especially people that live in remote areas like Eagle River, where staffing has a major impact if they jack with it. I want to know from a legal perspective. I mean, this isn't cut and dry. That's what you're telling me?
That's what I'm telling you. It's not
So,
cut and dry.
I mean, and this is the first time I'm coming out on the record saying it, but I will say, I'm not gonna support anything that messes with the equipment, staffing, when it comes to police and fire. Because quite frankly, that's something I think politicians, we're ultimately responsible for the overall budget. But when I have a mayor or a city manager who maybe doesn't understand the impacts, or maybe they're ignoring the impacts in the remote areas, I'm gonna do whatever I can to protect the public. And this is one that I have heartburn with. I don't like gray areas when it comes to public safety.
We can, and
Let's try to avoid debate.
we'll do that in debate, and.
But, Ms.
yeah.
Johnson, do you have anything you want?
No, it's just, I see safety and risk as something that we're addressing in here. We're allowing for everybody to participate in the discussion, and we are a self-insured city, so.
So, get a little clarification on this particular aspect. My understanding is, under the code subject to referendum, scheduling and equipment and staffing would be reserved exclusively for management. Is that correct?
Well,
Close to it.
the only thing I would say to this, yes, there's text in it that adds that language to this section.
It could always be negotiated
Well,
somehow.
and I'm not sure, yeah, the word exclusive is a little bit misleading because, as I was gonna say to Ms. Demboski's point, the assembly provides guidance, there's a code provision in 370 about giving guidance up front before negotiations. The Assembly sets budget, can provide directives within the budget and how staffing is going to be done. So I wouldn't say that it's exclusively the purview of the administration.
But mostly, rephrased, in the code subject to referendum, management rights are stronger with regards to those aspects than the S version that we have in front of us.
Yes. Well, actually,
Yes, because of that added sentence.
the added sentence at the top that has a call out
Right.
specific to the Assembly, that's different. So the administration needs to make a better, more clear
Right.
statement that they're deviating from management rights.
And one other thing that it was brought up in our committee meeting, and in a lot of respects, number 7, determine the methods, means, personnel by which government operations are to be conducted, is already in the current code. And that is staffing, scheduling, equipment. But what we're doing is just sort of saying that includes this, but that already does. That sentence says that.
So why do you have to change it?
Because I feel that we need to remind the city that it's their responsibility. But that's in for debate.
Sorry, Mr. Steele, you wanted to jump in on that?
I don't want to debate, but you can't, it's fine to have that statement, but you can't manage an emergency from the 8th floor. You've got to have on the
That's
ground
debate.
decision making, so
That's
it has to
Okay,
be. so-
okay.
Okay, so number 3.
Clarification's good, it's not, okay. We'll get to that too.
Number 3 is similar to number 2, so I think we're already, there isn't.
The same
Same
debate
thing,
is
yeah.
present in both of those.
Number 4, if you could give a brief history of the ERP.
Sure. I've tried to summarize the history and the response, but essentially, prior to 2005, your qualification to be a member of the ERB was that you had to be impartial, whatever that might mean to folks. In 2005, under the Bates administration, that was changed so that there was one person who had management experience, one person with labor experience, and one person from the general public. This makes no change to that notion. There was concern by one union that perhaps that the board was one-sided, as I indicated at the ad hoc committee meeting. I'm not aware of any proposals other than AO 37 to address this concern. I'm not aware of any ERB decisions that were appealed on that basis of not being impartial. So I don't know how to address that concern other than to say that there's nothing on the record that I'm aware of that makes that allegation in any formal sense.
Number 5, and this is one we also reworked. Dennis.
Right, so number 5 deals with definitions and how those definitions play into who is or is not eligible to be part of a bargaining unit. The list is in 060 on page 9, but the definitions are at the beginning of the ordinance. And one of the issues that came up, at least with respect to supervisory, was the addition of time and attendance responsibilities being part of an indicator as to whether or not you're supervisory. And there was some concern that just because you had time and attendance functions, did that then make you a supervisor? And the answer is no. It's one of a list of things you look at in order to decide whether or not you're supervisory. And I believe it was Mr. Steele had a suggestion to maybe modify the way that list reads, and Ms. Johnson asked us to incorporate that. So if you go back to the definition, which is on page 5 at the top, I don't know that it perfectly captures the way Mr. Steele said it in the meeting, but the idea is that you have a list of factors, and certainly if you directly supervise people in terms of discipline and grievance procedures and so on, promotion, recall, layoff, all those things are indicia that you're a supervisor, as is approving time and attendance. Now, there are a number of people that nominally approve or make the entries from PeopleSoft or Kronos PeopleSoft entries and things like that. That doesn't make them supervisory. So there was not an intention here to all of a sudden flip certain people just because they had a time and attendance function, but it was recognized when we were going through the Kronos process that we needed to tighten this up and make that an indicator of supervisory responsibility.
And the other thing we added just before, is in our whereas. And-
Back on page 1.
Right, line 13 to 15, whereas it's the intention of the municipality, the definition changes of this ordinance for supervisory and confidential employees will not be the sole criteria used to reclassify current employees out of a bargaining unit.
Thank you, Mr. Johnson. Mr. Attorney, you had a question on that point?
Ma'am, how many people will be affected by this change? And their ability, we've asked that question from the administration,
Right.
and be able to tell us.
Because it really, at this point, would not be a defined unit. This legislation is for something going forward, and that's why I added that whereas. So, you know, even if there were something that the administration came up with that fell into this, and if a bargaining unit disagreed, it would go to the ERP. So I don't see how you could answer that question with our current situation.
Ms. Dombrowski, do you have something on that point?
I do. My question is, you know, it's following up on what Mr. Trainey's asking. You know, I'm thinking about, again, police and fire. So you're telling me a sergeant on the police force now, because he's a sergeant, he's gonna be excluded from the union?
No, and that was, I've spent quite a bit of time with both those groups on this and with IBEW as far as leads. And so that's why, and Mr. Wheeler, as far as how you would look at this, and Mr. Wheeler, could you just sort of help her understand what this means in legal terms, that we're not.
What might be more helpful for me is if you can show me the criteria, the specific criteria. You know, I heard what you said about you're not exactly sure which ones will or won't be, but how, I need to understand before I vote on this, how I can determine who will or won't be. I need to know that before I vote on it.
First of all, those sergeants, and we, you know, the police is an interesting one, because you have sergeants who hire, do some of the hiring, the firing, but what they do is they recommend to the chief for these hiring academies. So, are they ultimately responsible for hiring, firing? No, it's the chief's responsibility with the information they give them. Mr. Wheeler, we used his example in his department. He might have an attorney that he's interested in hiring, but it's actually an executive position, so it's the mayor. So, it's pretty easy to see why those would still be within the union. And this doesn't affect them. And we spent a lot of time working on this, talking to the unions. We at one point thought we would, you know, should we list them all out? But if you get into lists, you know, that can wrap us around the axle really quickly. And we could spend a lot of time in assembly meetings adding and subtracting from the list. You know, so the general, and could you just sort of strengthen your opinion, your municipal attorney, because I asked for municipal attorney's opinion.
Right. Typically, these things come up when there's been some sort of a reorg and you're looking at changing job descriptions, and you go through this formal process of rewriting the descriptions and indicating what it is your intention is as to that position. It goes to that review, and if in that review the administration says, well, this position now has functions that look supervisory, then you go to the union agrees, disagrees, you go through that process. If there's no agreement, you go to ERB, as Ms. Johnson indicated. That's the norm for how you analyze whether there's going to be a change. What we're trying to indicate here in the whereas clause is that just because we've added this as a criteria, it doesn't flip the switch. And now people that have not been treated as supervisors before suddenly are and out of the bargaining unit. That's not the intent here. The intent is going forward, when we analyze positions and try to make a determination as to whether they are or not supervisory, this is one of many indicators.
And can I just follow up on that question? So, okay, so it's one of many indicators, and I can read in here some, you know, of the other things, but do you have a specific, okay, here's your criteria, can you give it to me? Like, this is my list of criteria, these are the people that are gonna fall in, these aren't, I recognize you put a whereas.
It's in the definition. So originally, the way the definition was written, you had to have some or all of the following. It was confined to what was in that list. Now it's a little bit softer based on the way we took the suggestions, that you look at all factors, the totality of the circumstances, if you will, and those factors include the things in this list.
So they have to, and when I read it, I saw they hire, transfer, transfer, promote, discharge, assign, approve, time and its reward, they have to meet all of these criteria or just some of the criteria? That's, I guess, where I'm getting a little bit bogged down here.
Right, right. So
Because
you-
to me, that leaves it, again, very gray.
Well, for a
and-
long time, it's been some or all of the following functions.
Some are all for a long time.
That's
Yeah,
what,
the
that's what it was
current
written for a long time, okay?
But
And that was her original proposal, that some or all language remains unchanged. Now, in her latest S version, these criteria just become part of a bigger picture. There's a list of things here to look at. How many do you have to have? Well, that's gonna be a judgment call. Is it 5, is it 6, is it 3? Depends on the nature of the position and what they're doing, and it depends on the agreement between the administration and the union, and if that doesn't work out, it depends on the judgment of the ERB, and if that doesn't work out, then theoretically, one party or the other could appeal it to Superior Court.
Sure. And the last question I have, the whereas clause that was added to help add clarity to intention, that whereas clause, from a legal standpoint, does that have the effect of essentially law right here? Because my understanding is, this is what we mean to do, but the law now therefore afterwards, this is what we are doing. So,
Yes, if the Assembly adopts that language, then yes, it would have a force in law, because if there were questions about how this is supposed to work, either side would point to this whereas clause and say the intention of the Assembly is not to have somebody flip solely on that criteria.
thank you.
Mr. Trainee, you follow up on that?
I guess Gerard gave us the best response to your question. He says in here, I looked at his amendments, municipalities not responded to multiple requests for lists and job classifications that intends to remove from collective bargaining. And that's the same, they're having the same problem we're having. Amy. So,
Ms. Johnston?
Okay, number 6, it was how do we come up with a 3-year projection? And you'll see in here, the CFO listed her resources that she uses for the 6-year fiscal plan. And we've been working on a pretty solid 6-year fiscal plan for quite a while. And sort of self-explanatory.
My favorite part of this whole thing is on page 16, line 5. Please continue.
Number 7, I had the mediation and whether we should have the FMCS as a default or whatever. I really was kind of leaving that open to if Mr. Trainee wanted to do amendment. I didn't really feel one way or the other on it. So I just left it. But anybody's welcome to do with that, whatever. Number 8, this was a very interesting, and when you go through legislation, it should always be a learning curve on both sides. And I think it has been, at least on my side, and I hope and I don't like ties, but whatever. The question was removing workplace morale and past practices. And my intent and my philosophy is in our reaching agreements with the unions, that we always sort of crank it back to a clean sheet of paper, because time and technology and workforce has changed. And so that was my interest in getting rid of past practices, is that if you keep building on past practices, you might have what I call the permanent fund dividend issue, where when the permanent fund dividend first came out, it was highly labor intensive, and now it isn't. And what would you have done with that whole workforce using past practices? But I learned from Mr. Evans that past practices is actually something that can stop both sides from getting into a very interesting situation where if there was disagreement, then the unions also could work to the contract and only do what was listed in the contract. So I put it back in. Workplace morale to me is a very subjective term, and I I couldn't go there, you know. Any Title 21 this semester, you're gonna find out, and we still have subjective things in there. We just can't put that type of stuff in code because it's in the eyes of the board. Okay, number 9. Let's see.
Number 9 caused some concern, but it wasn't intended to cause concern in that regard. When I read paragraph 8, which starts at the bottom of page 18 of this draft, it talked about subject by subject arbitration. And the problem was that it only references A1 unions. Those are the ones that have binding arbitration like police and fire. But it's been our practice that A2 unions and A3 unions also have the same subject by subject arbitration if they go to arbitration. So to make this section work, I just take out that first sentence so it's not referencing just the A1 unions. That was the only purpose in making that change, was to clean that up.
Number 10. Again, Mr. Will, this is quick.
Number 10, timing. Timing of labor agreements, side letters, administrative agreements, LOAs, whatever you might call them. There was some concern about whether this language would cause them to expire in some way differently than the CBAs. And the answer is no, to the extent that a CBA expires on a given date, the related LOAs would also expire on that date unless the LOA had been approved with some extension language built into it. In any regard, these things can be extended by mutual agreement, so there wasn't any intent to do anything other than have them terminate in conjunction with their related CBAs.
Number 11, and we spent a lot of time on the wording of this one. This is basically calling out anything that doesn't match the personnel rules, because personnel rules are default language. And it's not to not have things in the agreements that might be different from the personnel rules. It's just to have it called out so the assembly knows what they're approving. And my intent would be that it would be, as the agreement came to the body, wouldn't be something that the assembly would have to agree upon before they went into negotiation. And it could be covered very easily by an executive summary. It's just noting where there are differences. And I think as this process became more a standard process, that it would not be a difficult process to adhere to. Number 12, that's technical years.
Yeah, the EMS integration plan was proposed for deletion because it was seen as no longer necessary. This just carries that same concept forward. I don't remember there being any particular debate on it. Yeah, we were asked the question why, so I included it in the matrix.
And number 13, again.
Yes, the question was whether or not there would still be a right of appeal to Superior Court, and the answer is yes.
Okay. Ms. Johnson, any wrap-up comments or?
Save it for debate.
Fair enough. You want to briefly speak to your repealer?
I wanted to ask Julia a question on my repeal. Julia, this process on the 5th, do we first have to deal with my repeal of 37, then we can address 2014-80S or whatever version we're dealing with? Doesn't 37 have to be repealed by the body first? In other words, we can't just not repeal it, but substitute this for it? Or what do we need to do from your perspective, Julia?
In order to get the referendum off the ballot, then the assembly has to do the functional equivalent of what the referendum would do, which is a repeal. And so there has to be a repeal.
A two-step process, first to repeal and then?
Well, I think that at one point, there was an ordinance, which I thought was sponsored by the administration, but it may have been by Ms. Johnson, that purported to do both, that it was a conjunctive. It was that this ordinance would repeal AO 37 and it would go forward with these new changes, but that's not this one. This one is only amendments. So these amendments could be, in my legal opinion, these amendments could be passed, but
But still not
it
get it all.
would, there'd be a question as to whether the passing of these amendments would have the functional equivalent of the referendum.
And just for the information of the body, what I asked of Ms. Johnston as she worked on this version was that she not address the repeal, because in consultation with the clerk's office, our feeling was you had to have an absolute repeal, and then in some way, it doesn't necessarily have to go first, but have to have an absolute repeal to get it off the referendum ballot, and then we get to choose if we want to do something in its place.
I just wanted to make that public, so everybody understands what we're dealing with.
So I know Mr. Wheeler had his hand up, Ms. Johnston, Ms. Dombrowski, and Mr. Steele.
I just want to hear from Mr. Wheeler.
Okay, let's start with
He's
Mr.
right off the
Wheeler.
list.
Let's start with Mr. Wheeler.
Without commenting on whether it's absolutely required to do it that way, we agreed to do it that way. So this ordinance is set up and premised on using the old code prior to AO 37, which means that this is premised on the repeal first and then this.
Thank you. Ms. Johnston, you want to follow up on that?
Yeah, I have a question. Since this is an amendment to the old code, it really has, in my mind, I mean, it could do something with AO 37 or not, but it's an amendment of the old code, so would it make any difference if we address this before we address the repeal and timing as far as Tuesday night's meeting?
Well, you're, if the repeal doesn't happen, then you've got a problem.
How many angels are dancing on the head of that?
Yeah, so as a practical matter, just in terms of making it easy for everybody to understand what's happening, our recommendation would be to deal with the repeal first. At the same meeting, could you switch them around and still get the same end? I suppose you could, but it could be confusing.
So, yeah, it isn't, if we change the document, it's not the one that that all the signatures were based on. So you're actually voting then, or you're having the voters vote on a different document than what they wanted to repeal.
Well, no, this is premised on the repeal, and therefore there is no vote at the referendum.
This particular document is not subject to referendum.
Correct.
So it
Okay.
goes away at that point because we've
Done the repeal is something different.
I
Ms.
can't
Dombrowski?
help myself.
Oh, geez.
I know. Common
You
sense
don't have a
tells,
conflict, do you?
I've already been ruled I do not have a conflict, and
I just
I'm a
thought I'd
person
guess.
of hate. And yes, my husband is fireman. I think common sense, this is a procedural question, and common sense tells me if we're talking about, in order to institute this, and there's a ballot and all this, I mean, it makes sense to vote on the repeal first, and then deal with what we do after. I mean, and Mr. Chairman, that is your call, well, it'll be the body's call, but
Right.
that's my suggestion.
I will inform the body that the current agenda has Ms. Johnston's proposal going first and the repeal going second. Functionally, if we take both actions in an affirmative manner at the meeting, at the Tuesday night meeting, it doesn't really matter what order we do them in. The purpose of the order was so that members who might be uncomfortable with the repeal, were there not to be a replacement ordinance in place, could understand what the decision of the body was on the new ordinance before they made their final vote on the repeal.
Fair enough.
I was just trying to be nice.
Fair enough.
Okay. I believe Ms. Ray Jackson asked that we go through the amendments that have been proposed by the Coalition of Municipal Unions. Ms. Ray Jackson, do you have a particular way you wanted to approach these, or?
Thank you, Mr. Chairman. I really appreciate you agreeing to follow this format, because it just makes sense to me to deal with this today and post and comment today and not wait till Tuesday. We can just start with one by one.
So, the first one appears to make a series.
Page 27, line, page 27, line 20.
I'm sorry, I must have the wrong
You got
order.
yours set in order. Try this one first. Go to page 27, line 20.
Okay, that's, for those of you who have the handout, that's the last page.
You don't wanna go in order?
His order was different.
The vice chair is always kind of approaches things slightly
I'll
differently.
tamper down my OCD.
So, okay,
It is impossible. Or it's painful.
so this is additional language.
Comes in after assembly line 29.
Page 27.
Line 29. So this is one of the issues that Ms. Johnston addressed in her meetings, and Ms. Wheeler spoke to in regards to that changes of personnel regulations that require municipal or assembly ratification. And this clarifies that in addition to that, there's a responsibility of the mayor to inform the assembly of any variation from the personnel rules. And in no case will division in the collective bargaining agreement be voided after approval of the agreement by the assembly.
And actually, this, and we had meant to address this, and we didn't after our last meeting, and coming up with some language, and I understand the union's issue as far as this, nothing would be worse than the administration not citing the changes and then having to reopen an agreement because the administration, and I don't know if you could, take care of it in side letters or, we do stuff like this all the time.
Yeah, I guess in reading this, the question that comes to my mind is if this last sentence is a little bit maybe too much. In no case will provision in collective bargaining agreement be voided after approval by the agreement by the assembly. That seems to preclude us from
Having,
coming to a subsequent agreement and
right,
providing a letter of agreement between the two parties. So I think that might be a little bit too much, is just my thinking. So we might want to spend some time thinking about that before we vote on this amendment Tuesday.
and it really, and addressing it, how do we address it in such a way because of that fear? It's more of a fear of negligence,
Yeah.
and so, let's not go beyond, let's
Yeah.
not be fearful of too much.
Okay, so we know what it does, and we'll think about that. Mr. Wheeler, you want to add a comment to that?
I would. The first part, which is to make it the responsibility of the mayor, it is true that there are a lot of provisions in here where the mayor or designee, typically ER, comes forward. It may be that there could be some comfort level if the parties submit a joint statement with the CBA or letter that needs to be approved, and they've agreed that these things call out changes to the personnel rules, and that would maybe provide more comfort to the assembly that they're not going to have to revisit it.
Okay. Gerard, do you want to work with Mr. Wheeler on that one a little bit further? Is that okay with you, Mr. Wheeler? Sure.
And
And obviously include Mrs. Johnson in the conversation since she's the sponsor. Mr. Aslan, did you want to add?
Yeah, I just want to be clear on the intent there, that I'm hearing some general acceptance of the idea. Ms. Johnson said that she understands our concern and that we can work directly with Mr. Wheeler to come up with some language that would address both sides of the concern.
right, and then where we're dealing with negligence versus,
Yes.
the whole.
Okay. Yeah. So can we go back to the original order, Mr. Trains, okay with you?
If you want, the original order is gonna mess you up. It's easy to go to the next one, it's shorter. The original order has got you real long.
Okay, all right. So we'll go to the second to last page. You read these more closely than I have, I guess. All right, so this next one refers to pages 6 and 7, and this gets back to the schedule and equipment discussion. What do we do?
Okay, I was tuning out. Can you repeat where we are?
We're on pages 6 and
Page
7.
6, line 45 through 46.
And the amendment is the second to last page in the packet that was handed out. And this gets back to the discussion we were having on staffing and scheduling. And
management rights, line 45 and 46.
It would have been helpful to go in order, I'm just saying.
I'm sorry.
Well, Mr. Frank is correct. This one's a lot simpler.
It's okay.
The first
Okay,
amendment's really big.
go, I'm ready.
Yes, it is. This one's simpler.
Okay.
Okay. Basically, this would go back to the old language. Is that a fair summary? Okay. Okay. So we return to Title 37 prior to the Assembly's first action,
Okay.
if we approve this amendment. Okay.
So,
And-
so this action bring it back to the old referendum with strengthen it more than mine, and mine's on the top.
Right. Okay. Now the big one.
No, you're missing it. Go down to page 7, same thing, isn't it? Page 7, section 10.
Yeah, goes back to the old language. Yeah.
I want to make sure we also picked up page 7.
Yeah.
Yeah.
Sorry.
Yeah, okay. No, I got that.
Now you go back to the one.
All right. So this is the first, apparently 3 pages. That's tidy amendment.
Mr. Chairman?
Yes.
Thank you, Mr. Chairman. If I may, so, the last amendment that you mentioned,
Yes.
is there any discussion on it?
Well, we just want to clarify what it means. I would rather avoid debate in a work session.
Well, I'm not talking about debate, but, I mean, even on the first one,
We just
Ms.
like to
Johnson
have
made
it.
some comments about how she felt about it, and since you're the author, I'd like to, at least get some idea of how you feel about this amendment.
Oh, okay.
If you don't mind.
I thought I heard her comments earlier, but
Thank
if
you,
you want to
Mr.
repeat
No,
it.
I mean, seriously, I'll save it for Tuesday night in debate. I mean,
Okay.
we had this
That
exchange earlier.
That says
so.
a lot. Thank you, Mr. Chairman.
Okay. Thank you, Ms. Ray Jackson.
You're welcome.
All right, so the mega amendment. I don't even know where to start here.
Page 1, line.
Well, it affects
Page 1, line 11 through 19.
virtually a number of. Still leads. Yeah. Okay, so the first piece deletes the whereas clauses, or the 2 new whereas clauses, I guess. I guess if we're gonna take these up on Tuesday as individual amendments, I'm gonna ask that we move these individual paragraphs separately, because this is too much to do as one
I
amendment.
agree.
So, we'll just walk through them one by one. So is everyone clear what the first one does? Just deletes those those last 2 whereas clauses on page 1. Move into page 3, the second one, lines 18. Okay, this essentially deletes the new language that Ms. Johnston has suggested in her S version regarding access to confidential information, review process, et cetera, et cetera. That's lines 18 through 21. Everyone clear on that?
Might be easier.
Maybe. Okay, next one, page 5, lines 3 through 12. This essentially, again, retreats to the language that we had before the code change, correct? Okay. Okay. Next one, page 9. Line 40. Again, this simply deletes the change, goes back to the code that we had before. Page 10, lines 17 through 20. Again, this deletes the change, goes back to the old code. Page 10, lines 34 through 40. Same thing. Deletes the new language, goes back to the old code. Page 11, lines 14 through essentially, with the exception of the final amendment, which deals with the reporting to the mayor, all these amendments are of deletion of language that Mrs. Johnson has proposed and retreats to the old code prior to our changes a year and a half ago. Everyone clear on that? Any questions about that? You have a comment, Mr. Gray Jackson?
Thank you, Mr. Chairman. Not on any of this, thank you for indulging the body in going through these amendments. But there is one other issue, legal issue, in reference to security policy, and I don't feel comfortable expressing it myself, so I would really appreciate it if you would allow Mr. Asselin to express his concerns on this particular issue. I think it's really important.
About security policy?
Yeah.
Okay, is that somewhere?
No,
particular
it's
here?
not. It's a different subject, and that's why I'm asking you if you would indulge me and allow Mr. Asselin to address this issue, because I won't do a really good job at it, frankly.
Mr. Asley, if you kindly come
Thank
to the
you,
table,
Mr.
introduce
Chairman.
yourself and speak to the issue that Ms. Ray Jackson raised.
Yes,
Thank you.
particular. So I'm Gerard Asselin, the treasurer with APDEA, and then in this capacity as the chair of the coalition. And yeah, I appreciate the conversation that's occurring. I think it's going to be helpful for us to understand this. I will certainly answer Ms. Gray Jackson's question directly, but I also ask, just as a point of indulgence, if we could have collectively even just a couple minutes to talk about this, because although it may appear to be a lot and maybe potentially overwhelming when you went through each piece, I would ask that we also be given an opportunity just to talk to that briefly, if I may, once I answer Ms. Gray Jackson's question.
Let's make sure we get through Ms. Ray Jackson's question before our
Yes,
hour is up.
specifically in response to Ms. Gray Jackson's question, this relates to the IT section and the IT section of the proposal from Ms. Johnston, where what it's talking about is the removal of IT people from the bargaining units. And you know, I've in meetings with the rest of the coalition, we're trying to assess internally how many people do we think this would affect. I think we've arrived at, from our estimation, that it's 6 Anchorage Police Department IT employees that are yet still represented. We've seen a lot of movement within the municipality, and a lot of people in these areas in other ways have been removed from bargaining by other means. But we're talking about 6 IT people that work at the Anchorage Police Department. So directly to Ms. Gray Jackson's question has to do with national and federal standards that are established in the information security for criminal justice information, and that there are very stringent rules and policies that are in place on a federal level to manage who has access to that information. We as police officers obviously have to meet a standard. Our IT folks who deal with our internal computer systems and ultimately control and access to the criminal justice information also meet the same standard that we do. And I think it's something that, in the way that it's outlined in the statutes and the federal codes in these, is that there has to be a connection to the police department. And this may be a reason why these 6 people haven't already been eliminated. I know there was an effort in the past to consolidate the IT function to the municipality and have the municipality directly control that. That didn't happen. They're still working at the police department. So just caution the body to consider, again, you know, Ms. Johnston hasn't been able to identify, well, who will this ordinance affect? We think it will affect our six IT folks, and they're an integral component to the success of public safety as a whole. We have computers in every police car, every desk at the station, the computer dispatch system. I mean, I can go on and on about the complexity of it, and I wouldn't want us to go down the road of exempting employees and then ultimately that leading to some non-compliance with federal laws and federal procedures as it relates to information security. And so that was direct to Ms. Gray Jackson's question.
Ms. Johnson has a question
And
about
it
that.
would be my intention, I'll work with the attorney to make sure. I have a feeling that there's enough in place in federal law that just what you said is going to happen, but let the municipal attorney and I work with you on this, and we'll see if we can address those concerns.
Mr. Raslin, do you want to speak a little more generally for a moment?
And if I could, I think this is potentially the largest of the amendments that we're talking about. And if I could defer a little bit of time to our attorney, because he can encapsulate this in a minute or two at most. And
He's not good, I'll give him a minute.
I can name that soon.
Please introduce yourself, sir.
I will. My name is Will Aitchison. I'm the attorney for the APDEA. First of all, progress, right? By my count, and I know we count differently, Ms. Johnston had 52 changes in the code in this ordinance, and the unions are saying we're willing to agree to 49 of them. This just reflects 3. And the intent of these 3 things, first of all, with the personnel rules section, I understand, Ms. Johnson, what you're saying about be voided, but what be voided means, and I wrote this language, so what be voided means is that the agreement itself, simply because of non-compliance with notifying the assembly of variance from the personnel rules, that wouldn't void the agreement. It's not that either side could tear up an agreement, or it's not that we couldn't reach subsequent agreements, and I'm happy to work with Mr. Wheeler to encapsulate that. With respect to the management rights clause, our concern here, our presumption is that when you rewrite an ordinance, and even if you move words around or change sentence structure or whatever it might be, that a court later on is going to look at that and say, you must have meant something by doing that. And that's what our concern is about the management rights clause. We understand that management rights, there's a policy statement after it that management rights are negotiable. We think that's what it means. When you get to the arbitration criteria, we can see that you're not proposing changing that hours of work go to arbitration, or that equipment go to arbitration, or workday. We see all that, and that leaves us not knowing what the changes mean. And so that's why our response is, let's just go back to what the existing code was. We've never had disputes over this. It's never come to the Employment Relations Board. Let's just go back. And with respect to the exempt employees, the confidential and the supervisory employees, that's a tough one, because that takes bargaining rights away from some members, and so that's why the unions are balking at that. I've got a suggestion, though. The suggestion is, you have had the right for many years, you meaning the municipality, you've had the right to go to the Employment Relations Board to get people who are supervisory, confidential, or exempt excluded from the bargaining unit. The municipality hasn't done it. None of us in our collective memory can recall the municipality doing that in the last 10 years. For the APDEA, I go back more than 20 years. I can't remember it over the last 20 years. Our suggestion would be go back to the current code and then exercise your rights. You're giving the Employment Relations Board discretion. Go try to make it work for you. And if it doesn't work for it, then come back and rewrite the code. So that's what our philosophy was behind this. I took about lawyer time, I took about 30 seconds.
Okay. Do we have any final comments before we wrap up today? All right, I appreciate everyone's time. Thank you very much, Mr. Evans, for you and your committee's work. Thank you, Mr. Wheeler. We're adjourned.